Welcome back to my channel. We dive into a serious allegation. Blake Lively has been accused of lying, not just publicly, but in federal court.
Yeah, just know, like, you're gonna have to forgive some things. You'll see, like, some, like, maybe tape on the walls and, like, music that's gonna, the score is not done, things that'll, like, tweak and change. But by and large, it's the movie you'll see. But please go see it again August 9th, because it'll be even better. And we're nervous for you to see it today, but also just so excited, because I feel like I can trust that you guys know that it's not totally done, but you'll see.
She's being portrayed as someone who is allegedly hiding behind legal protections while trying to suppress a business's right to seek justice. According to Baldoni Friedman and their team, this issue goes far beyond just a legal argument. They assert that the right to bring complaints and grievances to court is protected under the U.S. Constitution. They cite the Norr-Pennington Doctrine, a legal precedent that defends the First Amendment right to petition the government, even if that petition causes harm to others, so long as the lawsuit isn't frivolous. In other words, as long as a lawsuit is filed in good faith and aims to address legitimate grievances, the party filing it cannot be punished just because it may negatively impact the opposing side. They argue that this case shouldn't be dismissed at this stage. A motion to dismiss is only meant to determine whether the complaint falls within the bounds of the law, not to weigh the facts or merits of the case itself. In this instance, they're saying it's premature to make a judgment. Blake Lively's contract was also brought into question, specifically regarding an alleged breach. There was a lot packed into this motion to dismiss. Now, I'm not a lawyer, and I'm not here to tell you whether these legal arguments are bulletproof or not, but what I can say is this. They're leaning heavily on the Norr-Pennington Doctrine, which clearly protects the right to file a lawsuit as part of the broader right to petition the government for a redress of grievances. The First Amendment ensures that Americans can seek action from their government, including through legal claims in federal court. Federal laws and civil procedures take precedence over state-level rules. So if a state regulation conflicts with a federal law or constitutional right, the federal position typically overrides it. According to the legal team involved, that's exactly what's happening here, and they believe Blake Lively's legal arguments don't hold up against federal protections. California law is at play here, and I think their argument is both strong and legally sound. But I want to zoom in on a specific detail. One of the key points she's making is that she has the right to bring these claims forward, essentially, the right to speak out against harassment, which is protected. She's attempting to invoke litigation privilege. But the opposing side argues that she actually made defamatory statements, and not the kind of statements she's claiming are protected. Remember how she said her allegations were already past the statute of limitations when she brought them to Wayfarer in May 2023? Well, they're saying, no, we're not talking about that. Instead, they're referring to a much narrower time frame, specifically from July to December 2024, when she, her husband, and her PR team allegedly made public statements, including to the New York Times, portraying them as sexual predators. The document says, Lively implausibly argues that the defamation claims arise from the 17-point list presented to Wayfarer around November 23. But they're countering that. While some of their claims might touch on that list, the actual defamation accusations stem from statements made during that July-December 2024 window. Now, where it gets really interesting is their argument about malice. This section of the response is critical because it essentially dismantles her attempt to claim protection under Section 47.1, a California statute meant to shield individuals making claims of sexual harassment. But that protection only applies if the statements are made without malice and based on reasonable facts. They argue Lively's claims don't meet that standard at all. They say she fabricated or grossly exaggerated her harassment allegations, turning non-harassing or even benign interactions into a calculated, malicious narrative. According to them, this was a strategy to take control of the film project and later to repair her reputation after some high-profile PR failures. A lot of what I've been suggesting or speculating about in earlier discussions, like how she may have used these allegations to gain creative control, is exactly what they lay out here. They even say it outright. She used the harassment claims as leverage in later negotiations. Lively was given an executive producer credit, a largely symbolic title often granted to talent of her stature. However, Wayfarer and Sony refused to offer her a full producer credit, arguing that it didn't reflect the limited role she was expected to play. They didn't ask or require Lively to contribute beyond her duties as an actor and executive producer. While the production began with what seemed like a promising collaborative relationship, Lively reportedly had other plans. Referencing a 2022 Forbes interview, they highlight a quote in which Lively says she needs authorship to feel fulfilled, something producers and directors often interpret as a rug pull, since they hire her as an actress. That, they claim, is exactly what happened. They argue Lively's controlling behavior led to constant disruptions during production, resulting in avoidable stress, chaos, and delays. They assert that her allegations of sexual misconduct were brought up not out of genuine concern, but as a tactic to gain more control over the project. When the strike ended, they claim they were suddenly presented with a list of 17 non-negotiable demands from Lively's team, accusations against Baldwin Heath and others among them. Wayfarer and Sony attempted to revise the document to correct falsehoods, but her legal team insisted it be signed as is. They complied, fearing massive financial losses, job cuts, and a ruined relationship with Sony. Though the demands were largely things already in place, they claim Lively used the situation to pressure Wayfarer into giving her editorial control, her own cut of the film, removal of Bellin from all marketing, sponsorship for a PGA mark, and exclusion of Bellin from the premiere, actions Wayfarer described as real-time extortion. They point to a letter sent by Mr. Heath to Wayfarer, saying they were being extorted by Lively. To support their claim that these accusations aren't retaliatory, they raise them as they happened. They delivered their response directly and unequivocally. In the FAC, the defendants methodically dismantle the 17-point list of accusations laid out in the complaint, spanning 391 pages, including Exhibit A. They assert that the claims made are either entirely fabricated, seriously mischaracterized, or grossly exaggerated. Essentially, they are calling her a liar, plain and simple. Now, it's worth noting, in motions to dismiss, it's common for the defense to submit sworn declarations. We saw this in the Jed Wallace case. He filed a statement under oath, denying the allegations against him. If he lied, and that can be proven, he risks legal sanctions. But in contrast, when Ryan Reynolds and Ms. Lively filed their motion to dismiss, they did not submit any sworn declarations. No statements under oath. No personal attestations denying the claims. To me, that says a lot. In every motion to dismiss I've ever filed, I've had to sign a sworn declaration. If you're innocent, that's usually what you do. Here's what the defendants claim she lied about. Lively allegedly said there was no intimacy coordinator, yet she was made aware of one being hired 6 weeks prior to filming. She reportedly refused to meet with that coordinator during pre-production, forcing Baldwin to communicate the coordinator's suggestions herself. She claimed Wayfarer team members tried to be around her while she was undressed or breastfeeding. In reality, they state she breastfed openly on set, and her trailer was always guarded. No one entered without her prior approval. In fact, the FAC includes a text from Lively inviting Baldwin into her trailer while she was pumping breast milk, after the alleged harassment occurred. She claimed she was forced to appear nearly naked in a birthing scene. But according to the FAC, she wore black briefs, a hospital gown, and a pregnancy suit, with only her legs exposed. She said Wayfarer hired a random friend of Baldwin's to play a gynecologist. In fact, the actor is a Shakespearean-trained professional with an MFA in acting from UCLA. Finally, she alleged that Jamie Heath showed her pornography during filming. The defendants firmly deny this as well, stating it's false and misrepresented in context. Lively was shown a single non-explicit clip from the video of Heath's own son's home birth. She then falsely alleged that Baldoni had harassed her during the filming of a supposedly soundless slow dancing scene. However, this claim was definitively disproven by raw footage that included sound, footage Lively apparently did not realize existed. Lively also falsely accused Baldoni of fat-shaming her. In truth, he had privately contacted her personal trainer to discuss her weight in preparation for a lifting scene, due to his long-standing back problems. She further claimed there was no such scene in the script, but the relevant excerpt is included in the first amended complaint. Another false allegation made by Lively was that Baldoni admitted to committing sexual assault, when in fact, he shared that he had been a victim of such an assault. Claims that he is a predator who crossed boundaries, such as during a car ride where she said he made her reevaluate things, are denied by him. These examples, they argue, only scratch the surface of the scope of her fabrications. In their strongest terms, they assert that Lively's accusations of sexual harassment and retaliation are entirely false, and that she knew they were false from the outset. They believe she acted with malice, and made these claims without a reasonable basis in fact. According to them, this matter is not appropriate for dismissal at this stage. It is an issue of fact that must be determined in court, and they believe the law supports that. Additionally, they argue that Section 47.1 does not apply to statements made by Sloan or Reynolds on Lively's behalf, as these are third-party communications not protected under that statute. They are pointing to her falsehoods in an effort to demonstrate actual malice. They're also highlighting issues previously mentioned, such as her failure to report these claims to the proper authorities. The complaint notes that while Lively filed with the Civil Rights Department, CRD, she never intended for them to investigate the matter. Instead, after making her claims public, she waited several weeks before filing a lawsuit. While she legally had up to a year to file, most claimants submit their lawsuit on the same day they receive a right to sue notice. In her case, she waived the CRD's investigation, never reported the incidents to HR, and took no action to substantiate her claims through official channels. To support the argument of malice, they cite her refusal to have the claims investigated, her demonstrated anger and hostility, and her reliance on biased or unreliable sources. These factors, they argue, suggest that Lively had serious doubts about the truth of her statements. After all, if she truly believed her allegations were valid, she would have allowed CRD to conduct an investigation. You could have allowed the EEOC to investigate or filed a formal complaint with HR. That would have triggered a proper investigation. The claim states that malice is presumed if the defendant's story is fabricated, purely imagined, or based entirely on unverified information. It questions Lively's motives, suggesting she made these statements with the intent to harm the Wayfarer parties. Regarding the sexual harassment allegations, the filing argues Lively knowingly made false claims based on her own described experiences, which were either grossly distorted or outright lies, even in sworn documents. According to the case, she and her co-conspirators carried out a coordinated campaign to exaggerate harmless interactions in order to push a false harassment narrative. The intent, allegedly, was to intimidate the Wayfarer parties and use that fear to gain power. The argument continues that this entire narrative was constructed so she could take control of the film. And if you're familiar with how Hollywood operates, such tactics, using false allegations as leverage, aren't unheard of. Both men and women have used this form of extortion to advance their own goals. This isn't to say the #MeToo movement is invalid or over because of Blake Lively. Real victims exist. But others have exploited the same language and claims for personal gain, and according to this case, Lively is one of them. The lawsuit claims she succeeded in gaining editing control and even manipulated her involvement with Sony to threaten withholding participation in promotions. They point to a letter from Jamie written back in June as evidence that this extortion claim isn't new. On page 23 of the FAC, it alleges Lively initially secured a producer credit and later obtained a prestigious PGA mark by coercing the Wayfarer team into granting both the credit and a support letter, actions Jamie reportedly recognized as extortion. These accusations alone are enough, they argue, to support a civil extortion claim. Despite Lively's defense that she didn't gain anything of value through threats, the suit contends she did. Specifically, the producer credit and PGA mark. Even if no money exchanged hands, they argue it still qualifies as extortion under the law. The FAC also claims Lively and Reynolds demanded that the Wayfarer parties issue a self-blaming public statement to cover for Lively's PR controversies or face aggressive press attacks. The implication was clear: comply or risk having your business destroyed. As for the outcome of the extortion claim, it remains uncertain. But based on the arguments and the contractual breach allegations, the plaintiffs seem to have a compelling case. She argued that the plaintiffs failed to state a valid claim because they didn't identify a specific contractual provision that was allegedly frustrated. Similar to how Ryan Reynolds once said, "Well, you didn't identify exactly what it was that I did or said." Essentially, she was using the same playbook. Additionally, she maintained, with a straight face, that she did not fail to cooperate with the parties. However, the Wayfarer parties have indicated they can and will amend their complaint to add further detail if necessary. As it stands, they've already provided examples of how she allegedly violated the contract. The agreement required that Lively exercise her right to consult and approve certain aspects of the film's production and marketing in a reasonable manner, not in a way that would hinder Wayfarer's full and timely development, production, or exploitation of the film, or that would impose additional costs. The contract further specified that Lively could only terminate her performance under extremely narrow and inapplicable circumstances. Yet, as detailed in the first amended complaint, FAC, she repeatedly threatened to terminate both her acting and promotional services. She also agreed not to interfere with Wayfair's full enjoyment of the rights and privileges granted to them. Her claim that she didn't frustrate any specific contractual provision is, therefore, without merit. In summary, the contract gave her the ability to provide input on the production and marketing, but not in a way that caused delays, increased expenses, or blocked the film's release or promotion. She was only permitted to exit the contract under very specific conditions, which the plaintiffs argue were not met. Despite this, she repeatedly threatened to withdraw, violating her commitment not to interfere with Wayfair's ability to use her acting, likeness, and promotional participation. Ultimately, they assert she abused her approval rights to delay and obstruct the project, and that her actions impaired their ability to complete and market the film, resulting in a breach of contract. Their overall position is that her conduct was obstructive, unreasonable, and financially damaging. Their response to her motion to dismiss is far more substantive than Blake's was in his case with Jed Wallace. Instead of spending 10 pages summarizing the background, they used specific allegations from the first amended complaint to directly rebut her dismissal arguments, which is exactly how a response like this should be done. They present strong arguments, and I don't see this being thrown out. Much of what she's arguing is either frivolous or hinges on factual disputes, not legal ones, meaning it's for a jury or fact-finder to decide, not the judge at this stage.
Outright lied, fabricated the events in question, even in sworn legal documents. Lively and her co-conspirators engaged in a coordinated campaign to exaggerate benign interactions in service of a false narrative that she had been sexually harassed. They did so to instill terror in the Wayfair parties and leverage it to accumulate power. They're saying the whole premise of these allegations was so that she could take control of the film. And if you know anything about Hollywood, don't be disillusioned. People use extortion like this all the time. Women and men will extort other people on the premise of filing false allegations for whatever in order to get what they want. So this idea that, Me Too is dead because of Blake Lively, no. There are some people that get harassed and have been victimized on sets. There are also other people that weaponize these same claims to get what they want. And they're saying, Wayfair, is that she's of the party that used them to get power. And she did, because ultimately it was the document that she signed, made them sign, that gave her editing control. It gave her an opportunity to extort them and threaten them to get a cut with Sony, to threaten not to be a part of the promotions. And I am so glad they brought this up, because I pulled this letter that Jamie wrote about the extortion back in June as proof that this was not a new claim against them, against Blake. Like, they just made this up. Because again, on page 23, they say the FAC alleges that Lively obtained first a producer credit and then a coveted PGA mark by threatening and coercing the Wayfair parties into granting her the credit and writing a letter of support for that mark, an act that Jamie expressly recognized even at the time as extortion. These allegations alone are sufficient to defeat her motion to dismiss claim for civil extortion. So they're saying that, she extorted them to get that PGA credit, which is what so many of you guys have been saying in the comments. Yes, she did. She got something. She got the PGA credit. That's what they're saying too. So at the very end of that same argument, they say she further claims that she cannot have engaged in extortion because she did not obtain anything of value from them by means of threats. They say, as set forth above, that is untrue. She threatened her way into the valuable producer credit and PGA mark. But even were that not the case, it prescribes extortion, notwithstanding that the defendant ultimately obtained no money or property by means of this threat. Here, they have alleged facts sufficient to state a claim for civil extortion based on at least the demand that Reynolds and Lively, that if they didn't issue a self-destructive statement taking blame for Lively's press wars, or else the gloves would come off and they would attack Wayfair in the press. The FAC alleges that Lively demanded consideration, and if they didn't do it, they would threaten and destroy their business. I don't know what's going to happen with the extortion claim. I have no idea, but they have really solid arguments here. And when it comes to the contract violations and the issues of the claim for breach of contract or breach of implied covenant of good faith and fair dealing, she argued that they failed to state a claim of this for failure to identify a specific contractual provision that was frustrated.